This lecture is about the characterisation of laws enacted by the Commonwealth Parliament in exercise of its legislative power under the Australian Constitution. Section 1 of the Constitution provides, "The legislative power of the Commonwealth shall be vested in a federal Parliament, which shall consist of the Queen, a Senate, and a House of Representatives, and which is hereinafter called the Parliament, or the Parliament of the Commonwealth." This section gives the Commonwealth Parliament its legislative power. You should remember that the Commonwealth does not have plenary legislative power. Unlike the states, it cannot make laws about whatever it wants. It can only make laws with respect to matters over which it has the power to make laws under the Australian Constitution. Section 51 of the Constitution contains a list of matters that the Commonwealth Parliament has power to make laws with respect to. For example, Section 51(5) provides, "The Parliament shall, subject to this Constitution, have power to make laws for the peace, order, and good government of the Commonwealth with respect to postal, telegraphic, telephonic, and other like services." The Commonwealth does not have exclusive power to make laws with respect to the matters listed in Section 51. The states can also make laws with respect to the matters listed in Section 51. However, if a valid law of a state is inconsistent with a valid law of the Commonwealth law will prevail due to Section 109 of the Constitution, which is covered later in this course. Section 52 of the Constitution, in contrast, contains a list of matters with respect to which the Commonwealth has exclusive power to make laws. No state can make laws with respect to any of the matters in Section 52. However, the matters themselves do not really concern the states, so it is doubtful that the states could ever make laws with respect to them anyway. Our course considers 6 of the matters listed in Section 51: the trade and commerce power, the defence power, the race power, the external affairs power, the acquisition of property, and incidental power. By the end of this course, you will be expected to be able to answer a constitutional law problem question. The problem question will set out some facts and some legislation. You will be asked to determine whether the legislation is valid. This involves determining whether or not it is with respect to any of the matters listed on the previous slide. It also involves determining whether there is some constitutional limitation that makes the legislation invalid anyway. These are the 2 ways in which laws may be held to be invalid. If a law is not with respect to a matter in respect of which the Commonwealth Parliament has legislative power, it is not a valid law. And if the law is with respect to such a matter, but it contravenes a limitation on Commonwealth power, it is not a valid law either. The process by which you determine whether or not the law is valid is known as characterisation. That is the topic of this lecture. The textbook introduces characterisation in the following way. Sections 51 and 52 of the Constitution assign broad legislative powers to the Commonwealth Parliament in relation to a range of subjects and purposes. In constitutional discourse, the term characterisation refers to the process of determining whether a law falls within one of these heads of power. The question is whether the law relates to the subject matter or purpose of the head of power in a way that allows it to be described as a law with respect to that head of power. In other words, characterisation is the fancy word for determining whether a law is with respect to a matter over which the Commonwealth Parliament has legislative power. Characterisation is different to interpretation. Interpretation refers to the meaning of the words used in the Constitution. For example, in the last lecture, I explained that the power to make laws with respect to trade and commerce with other countries and among the states does not permit the Commonwealth Parliament to make laws with respect to intrastate trade and commerce. That is because the High Court has interpreted the words with other countries and among the states to encompass only interstate and foreign trade or commerce, an interpretation that is obvious from any reading of the text. Characterisation refers to whether a law enacted by the Commonwealth Parliament is a law with respect to a matter over which the Commonwealth has legislative power. For example, if the Commonwealth Parliament enacted a law that prohibited trading bananas in New South Wales, it could not be characterised as a law with respect to trade and commerce with other countries and among the states because it applies only within New South Wales. it would be held to be invalid. Remember, you interpret the Constitution, but you characterize the law. Characterization as a process is not unique to constitutional law. In fact, it involves nothing more than answering the same question you are asked to answer again and again as a law student. Is it legal? The only difference is that in constitutional law, the it is not conduct by some person. The it is a law made by the Commonwealth Parliament. Characterization asks whether the law itself is legal. To explain this process, I am going to move to a different subject, one that has nothing to do with constitutional law, Section 18 of the Australian Consumer Law. Section 18 of the Australian Consumer Law provides, a person must not, in trade or commerce, engage in conduct that is misleading or deceptive, or is likely to mislead or deceive. The application of this section in practice involves both interpretation and characterization. The interpretation relates to the meaning of the words in the section. What is a person? When is conduct in trade or commerce? When is conduct misleading or deceptive? When is conduct likely to mislead or deceive? These are all questions of interpretation. What do the words in the section mean? Characterization relates to what the person has done, the alleged breach of the section. Consider John, for example. John is not a duck, he is not a flower, he is not a chair, he is a living, breathing, adult human being. He may therefore be characterized as a person for the purposes of Section 18. John sells what he markets as miracle weight loss pills door to door and in the street. The exchange of goods for money may be characterized as trade and commerce for the purposes of Section 18. John knows that the pills do not work. This means his conduct in telling potential customers that they do work may be characterized as likely to mislead or deceive. John's conduct, therefore, may be characterized as a breach of Section 18 of the Australian Consumer Law. The characterization of Commonwealth laws follows the same process, although there are some features of the process that are specific to constitutional law and some principles developed by the High Court relevant to the characterization of particular sections of the Constitution. I will now turn to those two topics. We have already discussed the unique nature of the Constitution as a legal document. In the class on interpretation, we compared the Constitution to a statute, a contract, and a will. The Constitution is like a statute because it is a statute, and it is drafted in the same style as a statute. It is like a contract because it represents the agreement of the people with the government, on the one hand, and between the colonies that agree to form a federation as states, on the other. And it is like a will because those who made it intended for it to influence the affairs of the nation long after their own deaths. They are not here to tell us what they meant by it, so we are left to work that out for ourselves. These features are more relevant to interpretation than to characterization. The different ways of looking at the Constitution tie into the different theories of interpretation: legalism, originalism, progressivism, etc. The view you take of the nature of the document tends to inform the view you take of its interpretation. The features relevant to characterization have more to do with the specific way in which the Constitution sets out the scope of the Commonwealth Parliament's legislative power. The Constitution sets out a number of matters with respect to which the Parliament has legislative power. It sets out what Parliament can do. In this way, it is different to most laws. Most laws do not set out what people can do, they set out what people cannot do. There are no laws stating that people have the right to breathe or walk or dance or buy or sell things, for example. That is because law operates in a proscriptive way. It proscribes certain forms of conduct and leaves everything else on the table. This means that, when it comes to characterizing the legality of conduct in general, like in the example of Section 18 of the Australian Consumer Law I gave earlier, the task involves working out whether or not what a person did was forbidden by the law. In constitutional law, however, which requires you to work out whether a law of the Commonwealth Parliament is valid, the task involves working out whether or not the law does something that Commonwealth laws are allowed to do. That is why characterization in constitutional law is unique. It involves asking whether what has been done is something that can be done, not whether what has been done is something that cannot be done. That question only arises later when considering whether or not one of the limitations on legislative power, such as free trade in Section 92, or freedom of religion in section 116, or the implied freedom of political communication, operates to invalidate an otherwise valid exercise of power. I will now address the particular principles developed by the High Court relevant to characterization of laws. The High Court has developed two different approaches to characterization. The approach to take depends upon the kind of power the law has been made under. Most of the powers contained in Section 51 are subject matter powers. By this I mean that the Commonwealth Parliament has power to make laws with respect to a particular subject matter. For example, to make laws with respect to lighthouses or banking or marriage. These are all subject matters. Some of the powers, however, have been held to be purposive powers. By this I mean that the Commonwealth Parliament has power to make laws for a particular purpose. For example, for the purpose of defending Australia. The test for characterization of a subject matter power is different to the test for characterization of a purposive power. The remainder of this lecture concerns the nature of these tests and sets out which subsections of Section 51 contain subject matter powers and which subsections of Section 51 contain purposive powers. The general rule is that powers are subject matter powers unless the High Court has held them to be purposive powers. To work out whether a law made under a subject matter power is valid, you need to determine whether the law is with respect to the subject matter. In some cases, this will be very easy. For example, if the Commonwealth Parliament passed a law that prohibited the trade of gold in interstate commerce, it would very obviously be a law with respect to trade and commerce among the states. In other cases, it is not so easy. For that reason, the High Court has held, in a number of cases, that the validity of a law enacted pursuant to a subject matter power should be ascertained by considering what rights, liabilities, duties, powers, and privileges the law changes, regulates, or abolishes. This is the subject matter power characterization test. The words come from the judgment of Justice Kiddo in Fairfax and Federal Commissioner of Taxation. That decision may be cited as authority for the test, along with the grain pool case, in which all of the judges reaffirmed the test from Fairfax. In addition to the general test, asking what rights, liabilities, duties, powers, and privileges the law changes, regulates, or abolishes, the High Court has adopted other principles of characterization. In the grain pool case, it stressed that the practical as well as the legal operation of the law must be examined to determine if there is a sufficient connection between the law and the head of power. In Herald and Weekly Times in the Commonwealth, Justice Kiddo said that the law must possess a substantial connection with the relevant head of Commonwealth power. However, in the Tasmanian Dam case, Justice Mason said of that requirement that it does not mean that the connection must be close. It means only that the connection must not be so insubstantial, tenuous, or distant that it cannot be regarded as a law with respect to the head of power. The most important principle relevant to characterization of laws made under subject matter powers, apart from the test itself, is that the motive of Parliament is irrelevant to the validity of the law. One authority for that proposition is South Australia and the Commonwealth, which is known as the first uniform tax case. In that case, the Commonwealth enacted a law granting financial assistance to the states pursuant to Section 96 of the Constitution. One of the conditions it placed upon the financial assistance was that the states had to abstain from imposing income tax. At the same time, the Commonwealth enacted laws under the taxation power raising the federal income taxation rate. The states argued that the purpose of this scheme was to prevent them from collecting income tax. The High Court rejected that argument. It refused to view the laws as a scheme and held that the motive of Parliament with respect to each particular law was irrelevant to its characterization. Another authority is the Murphy-Oars case we discussed in the lecture on the trade and commerce power. You may remember that Murphy-Oars argued that the regulations prohibiting it from exporting zircon and rutile from Fraser Island were invalid because they sought to achieve a purpose unrelated to trade and commerce. The High Court rejected that argument. It held that the motive behind the regulations was irrelevant because the law was on its face with respect to trade and commerce. The position is the exact opposite where the law is said to be with respect to a head of power because of its purpose. Where the head of power is a purposive power, the High Court will consider the extent to which the law is a suitable means by which to achieve the purpose. When doing so, the High Court tends to ask whether the law is reasonably appropriate and adapted or proportionate to its purpose. I will return to this test in a moment. There are three accepted purposive powers. The first is the defence power in section 51(6) of the Constitution. Under this power, the Commonwealth Parliament may make laws for the purpose of defending Australia against external and internal threats. The second is one aspect of the external affairs power in section 51(29). That aspect relates to the power of the Commonwealth Parliament to make laws for the purpose of implementing treaties entered into by the executive. The third is the express incidental power in section 51(39) of the Constitution. Under this power, the Commonwealth Parliament may make laws for the purpose of executing other powers vested in the Parliament, the executive, or the judiciary. It is appropriate to pause for a moment and say a little bit more about this express incidental power in section 51(39) of the Constitution. The subsection provides, Parliament shall, subject to this Constitution, have power to make laws for the peace, order and good government of the Commonwealth with respect to matters incidental to the execution of any power vested by this Constitution in the Parliament or in either house thereof, or in the government of the Commonwealth, or in the federal judicature, or in any department or officer of the Commonwealth. This section contains one of the most important powers in the entire Constitution. It empowers the Commonwealth Parliament to make laws that carry the Constitution itself into effect. It is the power that, for example, empowers the Commonwealth Parliament to create federal courts. This is incidental to section 71 of the Constitution, which provides the judicial power of the Commonwealth shall be vested in a federal Supreme Court, to be called the High Court of Australia, and in such other federal courts as the Parliament creates. The express incidental power is said to be a purposive power because laws made pursuant to it tend to be made for the purpose of assisting the legislature, the executive, and the judiciary to execute their respective powers. In addition to the express incidental power, there is also what is often described as an implied incidental power. But the phrase implied incidental power is a bit of a misnomer. It refers to the power to make laws with respect to matters that are incidental or ancillary to matters contained in other heads of power. You may remember from the lecture on the Trade and Commerce Power that in Granville and Marrickville Margarine, Chief Justice Dixon and Justices McTiernan, Webb and Kitto said, every legislative power carries with it authority to legislate in relation to acts, matters and things, the control of which is found necessary to effectuate its main purpose, and thus carries with it power to make laws governing or affecting many matters that are incidental or ancillary to the subject matter. So there is not really an implied incidental power per se, rather there is power to make laws with respect to particular matters, and that power carries with it the power to make laws that are incidental or ancillary to. The power to make laws with respect to matters incidental or ancillary to other subject matters is said to be purposive because, where a law is with respect to a matter, but not directly about that matter, it is usually relevant to the matter because of its purpose. For example, in the Marrickville Margarine case, the law regulated the preparation and manufacture of margarine for the purpose of regulating the trade of margarine. For that reason, the purposive power test is applied to laws made under incidental powers. The purposive power test involves three steps. The first step is to identify the purpose of the law. The second is to determine whether the purpose is with respect to a head of power. The third is to determine whether the law is reasonably proportionate or reasonably and appropriately adapted to the pursuit of the alleged purpose. The purpose of a law may be set out in the legislation and will typically be apparent from the explanatory memorandum or second reading speech. For problem questions in this course, the purpose of the law will be apparent from the provided facts. That takes care of step 1. As for step 2, determining whether the purpose is with respect to a head of legislative power involves asking, is a law that does X for the purpose of Y a law with respect to W? This is something that must be done by an application of facts and reasoning. Determining whether the law is reasonably proportionate or reasonably appropriate and adapted to the pursuit of its alleged purpose involves considering whether the law goes beyond what is reasonably necessary or conceivably desirable for the achievement of this purpose. The majority in Macloy in New South Wales set out a three-step proportionality test for the implied freedom of political communication. That test has not been applied to the question of proportionality of laws enacted pursuant to purposive powers. However, it provides a sensible way in which to evaluate whether or not a law is disproportionate or not reasonably appropriate and adapted to its purpose. For that reason, I suggest you draw from it when evaluating whether a law enacted pursuant to a purposive power is proportionate to its purpose. The three steps of the test are: first, to ask whether the law is suitable for its purpose. This involves asking whether it does what Parliament intended it to do. If it doesn't, it may be held to be invalid. Secondly, if it does do what Parliament intended it to do, it involves asking whether the law is necessary. This means asking whether there is another way to achieve the purpose that has less undesirable consequences. If there is another way to do it, the law may be invalid. Thirdly, if there is not another way to do it, it involves asking whether the law is adequate in its balance. This is asking whether, even if it is suitable and necessary, does it nevertheless go too far by infringing some kind of freedom? If it does, the law may be invalid. This brings us to the end of the tests and principles to be applied when characterizing Commonwealth laws. We will be discussing these tests further in class when we answer a problem question relevant to the Trade and Commerce Power. If you have found this content confusing or difficult to follow, in the Seminar Materials folder on UTS Online, there is a subfolder called Guides. That subfolder contains a document called Steps to Characterization. The document reiterates what I have explained in this lecture and provides additional authorities. I recommend you read the document and the bits of the judgments to which it refers. It is easy enough to copy and paste the citations into Westlaw, open the PDF, and navigate to the particular page. This should give you a better sense of how the judges of the High Court have applied these tests and principles in practice.